Hello, everyone, and welcome back to Immigration Talk Show. Thank you so much for joining us. I'm Nipasa, and I'm going to be your host for this session that's lined up. And let me tell you that it's going to be a very insightful and an interesting one because we got a lot of new updates that you wouldn't want to miss out. And of course, we're going to continue discussing about the topic of discussion since it's going to be the second episode. And I will tell you who our guest is going to be. But before that, I have this very important disclaimer. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, I hope that you keep that in mind. And thank you once again for joining us. Today's discussion is going to be on this topic that you can see facing H-1B hurdles. Could 221G, RFEs, or port of entry issues lead to deportation? And this is going to be our second episode on this topic with none other than our guest of today, Attorney Chand Parvathaneni from SPB Law Firm, Dallas, Texas. So, Chand, thank you so much for joining us today as well. And I'm really happy to have you here.
Thank you, Nipasa, and hopefully we'll have a very insightful session today. And a lot of new things are happening. We are seeing a lot of new changes coming out in the last few days.
Right.
Hopefully we'll have a very productive session today.
Yes, and I think we should get to know, what is happening and what are the new things that you should be. I know every day we're waking up to new updates and new, policy changes, but I think the latest ones are something that we really need to keep in mind. So, Chand, maybe you could tell us about the major updates, that folks out there should not miss out on.
Sure. So, in terms of the major news, what is happening is in the last 2 days, especially starting from April 1st, we are seeing the consulates send a couple of emails to people. I mean, again, people who have had any kind of minor infractions with law. Maybe they had a traffic, maybe they had a DUI ticket, maybe they have some kind of a shoplifting on their record, some kind of a criminal offense infraction on their record. So if people have had any of these issues in the last couple of years, what we are seeing is all of a sudden various Indian consulates. We have seen emails from Chennai consulate, Mumbai consulate, Delhi consulate, and the people, especially the F1 visa holders, they're getting these emails, and these people are in US, and the emails are saying that their visa has been revoked and they have to either self-deport, if not, they'll be deported. And this is a recent thing that is happening. And the source for all of this is so last month, the Secretary of State, Marco Rubio, so he announced that there'll be very, very strong vetting. They'll be looking at social media. And there was a cable sent out to the consulates. And the cable, basically, what it says is it says that even if somebody's visa has been issued, or even if somebody's visa is about to be issued, there needs to be more vetting of social media. And they're going to scrutinize whether somebody has some political activism or somebody supporting a cause that is against United States, that is against the the traditions and the culture of United States. And what they're doing is because of this vetting, if they find somebody's real intention is not to just come here and be a student, but their intention is maybe to be a political activist or something else, their visas are being reconsidered. a lot of visas are being cancelled. And the major issue that we are seeing is if somebody had even a minor infraction, not a major criminal offense, but it's still a criminal offense. So those are the kind of people I think are being targeted. Their visas are getting revoked. So I think so. The message for everybody is be very very cautious. Always comply with the law. Even a small criminal infraction, you might think it's a very small infraction, but it is still an infraction. It's still a criminal offense. So these things could jeopardize your career. And so this is something that is very very recent. And previously, what used to happen is we used to see prudential revocation of visas. So we used to get emails even in the past for offenses, but it used to be prudential revocation of visas. The tone has changed, and we are seeing more and more people getting these kind of emails. And apart from that, another major update that we are seeing is to do with the green card process. Some kind of green cards. So USCIS has been told to stop the processing of certain green cards, and the cases that we are seeing impacted right now are asylum cases. So anybody that has been granted asylum, we've been asked. I mean, USCIS has been asked to put those cases on hold. So anybody that is going through the asylum process, even if they have an approval for asylum, their green cards are going to be delayed based on the new rule. And we don't know if it will be expanded to other green card categories in the future. But as of today, the asylum categories is getting impacted. And the last update that we have is the gender. So this week we had a notification from USCIS. Again, this rule was actually implemented last month, but they came up with a formal announcement this month. And this is in conjunction with President Trump's executive order in January. And what it says is there can only be two genders, either a male or a female. And people have to select either a male or a female because immigration documents require the gender, and only two genders are accepted. So somebody cannot say other and not disclose their gender. Gender is important, and as per the latest USCIS memo, only two genders are acceptable under law, and that is either a male or a female. And people have to select their gender. If people forget or decline to put their gender, their cases will be delayed. The adjudication of such cases where gender is not disclosed will be delayed. So the bottom line is people are assigned gender at birth as per the current regulations, and that gender has to be disclosed as a part of immigration filings. So overall, I think this is what I think we have been seeing in the last couple of days in terms of updates.
Thank you so much, Chand. I mean, yes, these are very important updates and we cannot miss out on. And I hope, friends out there, you are enjoying this discussion already. Not just, I mean, let me tell you, the discussion hasn't as yet started. These are just updates. And I would just like to remind you that if you haven't as yet, subscribe to our channel, subscribe and also hit that bell icon because you don't want to miss out on these latest updates. And our handle is at Immigration Talk Show. Go check out our channel. There's so much content you don't want to miss. But for now, stick with us because we have attorney Chand Parvathaneni from SPB Law Firm who's going to be here very happily to discuss about, yes, our topic of discussion. So, yes, I'd also like to say hi to Rag. Thank you so much for joining us on YouTube. He's saying hello, Nipa and Chand. So, hi, Rag. Always really nice to have you. I know he's a very frequent viewer. So, Rag, thank you and stay with us. And also, I see Saju, any chance to second lottery? So, Chand, anything before we start off?
Sure. So again, in terms of the percentage of selections, it was a lot better than last year. That being said, the percentage of selections is still under 50%. So we thought that we will probably reach at least 50% this year. It is probably a lot more than last year, but again, we are at our law firm, we are looking at around 40% selection rate. So that means that still even this year the demand has still been pretty high. And but again, in terms of a second lottery, this is what's going to happen. Everybody that has been selected right now, their companies have until June 30th to file the H1s. And normally, what happens is most of the companies file, but again, there are a lot of filings that are not done for various reasons. A lot would depend on how the economy behaves for the next 3 months. If the economy turns bad, a lot of companies will drop off. If the economy is strong, companies will want to file for these guys because there is demand and there is a requirement for these employees. So if the market goes bad, definitely we will not see all the filings. That being said, the rules have changed from last year. Compared to last year versus this year, evidence of bona fide job offer that is mandatory as a part of the filing. And what that means is previously contracts, client letters, vendor letters, these were not mandatory. This year they have to be included as a part of the filing. And what that means is some companies might realize that their purchase orders are not getting extended, or they don't have contracts to support employment from October 1st. And these reasons could cause a lot of people to drop out. So because of these reasons, I think there is a potential for a second lottery, looking at how things are going on and looking at the new rule changes that have happened for H1. So at least some companies might realize that rules are not same as last year in terms of filings. There is a lot more additional burden in terms of filing. We think that people might drop off for that reason. The other reason is the economy, and economy is something that we cannot predict. Maybe things will be very good in terms of economy in the next 3 months, people will file. But if economy is bad, because today if you look at the stock market crashed like anything today. We don't know if it is going to be a long term thing, whether the market will pick up or not. But if the market is weak, I definitely see more chances for a second lottery. And by end of June, because I think reasonably, I think we will know how many cases are getting filed, at least uh, based on what we do in our law firm, because we know what kind of selections we have, and then how many people are dropping off and so on. So end of June, I think reasonably, I think we will have a better idea. That being said, from the USCIS perspective, normally by end of July, they normally take about a month to process all the intake. And then probably by end of July, normally USCIS will make an announcement, either this way or the other way. And my guess is we more than likely will have a second lottery.
Interesting. Thank you so much, Chand, for that update. I'm sure many people are being very hopeful. And, when we had the news that all the results are out for the lottery, all the trickling is done. So many of them were commenting on our channel also, asking if that's it, if anything else is going to happen. But you never know, friends, because right now is what we can expect is more RFEs, right? We will see that everybody is, being able to submit all their documents and everything correctly. But even then, there are chances of a lot of a lot of RFEs and a lot of obstacles to come in. So they will be throwing at us, and yes, we will be seeing like who will be able to prove that they have all the evidence that USCIS requires. So we'll see to that, and only after that we'll get to know, right, Chand?
Right. And the thing is, at least at this point of time, we are not really seeing any bad RFEs for H1. And the administration, I think they're supporting the H1B program. And yesterday, President Trump,
Mhm.
he announced tariffs because eventually the hope is eventually the tariffs will help the country. So that is the goal. So even though it is painful at this point of time, tariffs were announced. And unfortunately, today, if you look at the stock market, stock market is reacting a little bit differently. The stocks crashed. It's a historical drop today. So we don't know how things will be. But again, yesterday when President Trump was announcing the tariffs, he was again talking about how he supports legal migration, how he understands that the country requires specialized workers in general, foreign workers in general. He just wants people to use the legal ways, legal migration. And what that means from a H-1B perspective is H-1B program. It is one of the legal ways for people to come and contribute to the US economy. So for those reasons, it looks like the administration at this point of time, they are in favor of H-1B program and looking at what kind of adjudications are happening in the last 2 months since President Trump has taken office. We do see that the H-1B program is not impacted at this point of time. At this point of time, we're not really seeing any bad RFEs, and cases are getting approved. And at least as long as the companies are complying with the LCA requirements, companies have a job offer. We are not really seeing any drastic change in the way RFEs are issued. That being said, we don't know because a lot will depend on how the markets behave, what kind of a requirement the country has for foreign workers, and all these things will play a part.
Right, Chand, right. And Saju, thank you so much once again for joining us with your question. But, we are really working hard to bring this to all you folks out there, not just Saju. So I really hope that you can see this, because week after week, question after question, you're getting your answers. And I really, really hope that you are subscribing to us. So if you haven't as yet, hit that subscribe button. And yes, I saw many just did. So thank you so much also. But you don't be the one who misses out. All right. So hit that subscribe button and also the bell icon so that you will be notified, and let me tell you, it really takes just a few seconds or maybe just 1 second to do that. And Thank you. So, Chand, I'm really, really excited about today's session. I know it's a continuation of what we discussed the previous week, last week. And yeah, the discussion is on facing H-1B hurdles. So, what do you think is going to happen? I mean, a week has passed on, and the results are already out. So, these few days, what do you have to say with all the changes? Do you see what we were discussing last week that is coming true?
So, in terms of USCIS adjudications, I don't think we are going to see like any major problems in the next 1 2 months. That being said, we are occasionally hearing issues at the port of entry, and at the port of entry, what's happening is I think there is definitely additional waiting, and if people are not able to explain why they're coming into United States, what kind of company they're going to work for, what kind of a project assignment they have. If the CBP officer feels that they're going to get benched and this company is not a genuine company and there is no project, those are the extreme kind of cases that we are actually seeing issues. And again, the number of people that we are hearing are getting sent back at the port of entry, it is extremely minuscule. The number is very small. That being said, once in a while we are seeing issues. And the common pattern that we are seeing is, if somebody has got an H-1B approval a long time back and they have not entered the country and they're entering the country for the first time, and they're not really able to convince the officer that they really have a genuine project, or if the officer suspects there's something going on, those are the kind of cases that I typically see get pulled over for secondary inspection. And then there is more digging. And in secondary inspection, most common thing that normally happens is the phones, the electronic devices, they are taken and they are scrutinized. And if something incriminating is found on their cell phones or their mobile devices, or the information on the cell phone device contradicts with what the employee is telling the officer, and the officer proves that the employee is misrepresenting something, those are the extreme kind of cases that we are seeing issues and people getting deported back. But again, in terms of the H-1B folks or the F-1 folks getting sent back, the numbers are still very small. The only thing we tell everybody is just be prepared to answer. And the main thing is, if one is coming to United States, they are required to follow the rules of uh, their visa status. If somebody is on H1, they're only supposed to work for that employer, only in that occupation, in that metro area, for example. So they have to convince the officer, and their intent should be to work for that company. The cases that, for example, I've seen an issue is that their phones got taken, and the officer found that the intention of that employee was to come and immediately convert and change employment to another employer. So they're already discussing with another employer. So the officer suspects that your intention is not to work for this company, and you're making a misrepresentation. So unless misrepresentations are found, I don't think people will have issues at the port of entry. And that being said, everybody's intention should be to follow the rules. Secondary inspections are possible, and if secondary inspections happen, the officers will definitely scrutinize their admission request, and based on that, they will take a decision. That's one thing we are seeing. And the other thing that we always tell people is, always make sure that you're working for a legitimate company. And what that means is, always get referrals, always talk to multiple people that you already know are working for that company. Don't work for a company that nobody has heard of, or nobody, you don't even have any references that know about that company. So at least do your groundwork. And as long as companies are legitimate, companies are actually paying their employees on time, most of the time the companies will not have an issue. It does not matter the company is small. The company can be a very small company, only have 1 or 2 employees. But if that company is following the rules, paying the employees on time, following the rules of the H-1B program, whether it's a small company or a big company, I don't think that will make any difference. It is if the company is not complying with the rules and regulations, even if it's a big company, we are seeing issues. So always get referrals, make sure you're working for a bona fide and a genuine company.
All right. Thank you so much, Chand, for that, latest update on these hurdles that are coming up for H-1B. And well, I see a lot of folks joining us. Bhargav, Papa Ki Pari, very interesting. Rag has a question for us. Saju, thank you. She says, she or he, I'm so sorry. Thank you, Saju, also for joining us. Fawad, Shashi Kumar. So stay with us, folks out there. We are going to take up each of your comments. That said, yeah, Chand, I do have my first question. And if you could tell us, if an H-1B applicant receives an RFE, What are the key factors that determine approval or denial, and how much time, this person can have, this applicant can have to respond to this RFE?
Sure. So RFE means a request for evidence, and all it means is it's a simple notice from United USCIS, and they just want some additional information. So RFE does not by itself mean that the case is getting denied, and majority of the cases, I mean, in high 90%, the cases get approved even after an RFE. So RFE does not mean something is really wrong. All it means is the officer is doing his job, which means they're looking through the petition and they just want some additional information before they can make a final decision. And sometimes even if everything is good, the company is a very big company, even companies like big companies like Amazon, Google, even those companies can get an RFE. So getting an RFE does not mean anything. It just means that we need to look through the RFE, look through the notice, see what exactly the officer wants, provide that documentation. That is all it means. And in terms of the timelines, normally what happens is the majority of the H-1B RFEs have 87 days. That is close to 3 months. So 3 months is the time that people have, the companies have, to provide the documents back to USCIS. So again, sometimes you need to take a lot of time because sometimes they ask for a lot of documentation, and you want to make sure you provide thorough documentation back to USCIS. So what that means is take your time and provide exhaustive list of documents back to USCIS. Very rarely what happens is they issue the RFE as a notice of intent to either deny or revoke, for example. If it comes as a notice of intent to deny, in those cases, people have only 30 days to respond back. So majority of the time it is 87 days. Very rarely it is 30 days. And that is the first thing that people have to keep in mind. The deadline is super important. If you cross the deadline, USCIS will deny the case for abandonment. So the timeline is very important. The timeline is on the notice. So the notice will clearly say what is the deadline. So the first and the foremost thing is comply with the deadline. The deadline is super important. You cannot not meet the deadline. And then what they're also looking for is compliance. So whether it's an H-1B RFE or an F-1 change of status RFE or some other kind of an application, they want to make sure one is complying with the requirements of that particular visa status. So for H-1B, what USCIS wants to know is they want to assess and make sure that the applicant qualifies and the sponsoring employer has met all the requirements. So what they want to make sure is they want to make sure the job qualifies as a specialty occupation. So in the face of the petition, if they feel that the job is a specialty occupation RFE, they will not even ask in the RFE. Some cases, what happens is USCIS is not really satisfied that that particular position is a specialty occupation RFE. So they might issue an RFE and say, hey, now you prove that it is a specialty occupation RFE. So if the RFE requires that, provide that information. And most commonly for H-1B, the RFEs talk about the educational and experience qualifications of the beneficiary. So it is very common to see an RFE where it says, prove that your beneficiary qualifies. And it's a very common RFE. And what that means is you just have to prove, maybe get some evaluations, or maybe talk about the coursework that the employee has done, maybe talk about the experience that the employee has, and prove the beneficiary qualifies. And again, if suppose the employee does not have a proper degree, maybe somebody has a mechanical engineering degree, but they have a lot of IT experience, but they're applying for IT job. These kind of RFEs are pretty common. So simply they come back and say, your employee does not have the right degree. How does he qualify? So these are the kind of things that could come out. Or sometimes they might simply say, you, the petitioner, the employer, prove that you're a legitimate employer. So prove and show us all your company documents, maybe your lease documents, maybe your tax returns, and so on. So the bottom line is look very closely at the notice, see what documents they're asking. Every document is crucial. No document is not important. If the officer has asked for a particular document, there is a reason for it. So it has to be explained. In case you do not have the document, that is okay. You just have to explain and provide some alternate documents. So completeness and accuracy is super important. Timing is super important, and the way you document is super important. And most of the time, the employers, when they get an RFE, they're very cautious. They try to provide all these documents, and doing so and ensuring that you provide these documents before the deadline is the only way to guarantee that USCIS properly adjudicates the RFE. And at least on a high level, majority of the RFEs do get approved. So nothing to panic. The only thing is worry about the deadline, worry about making sure that all the documents are provided. And doing so, most of the H-1B RFEs typically end up in an approval.
That is very nice. Thank you so much for that hopeful note, Chand. And we do have a lot of questions from our audience. We are going to quickly take them, but you were also talking about the stock market crash. I mean, sometime back when you gave the update. What do you think is the major cause, and how is it affecting immigrants or going to affect more immigrants? If you can relate it to that also.
Sure. So when we talk about H-1B program in general, H-1B program is something where the corporations, the US corporations hire foreign workers. So when we talk about corporations, the corporations are very, very integrated with the stock market, because if the stock market is good, the big companies, for example, if the stock market is good, their board will let them like open up more projects, do more hiring, and so on. And if the big companies open up projects, the smaller IT companies who do staffing, who do IT services, consulting, and contracting, those companies will get more projects. So the bottom line is, since H-1B program is entirely dependent on uh, US corporations, and then US corporations, especially the big corporations, drive like for example, what kind of technology hiring is required to be done, and H-1B program is mostly into technology hiring. So all these things are interconnected, and what that means is, if the stock markets don't do good, you can expect a lot of the big companies freezing their projects, freezing their hiring, and they will not initiate new IT projects. So IT projects will be put on hold. So this could have a ripple effect on the H-1B program. This could have a ripple effect, because only if there is market demand, only if there is a need to do new IT projects, people need to hire, the companies need to hire the H-1B employees. So we are just hoping that whatever happened today. So today the stock market crashed, historical levels of crash, and right now, a couple of minutes when I checked the market, I think it was down 1,500 points. Dow was down 1,500 points, and again, the stock market sometimes are very erratic. It could be a temporary blip. If it's a temporary blip, that's what we all hope for. I don't think it is going to impact us bad. But again, if it continues and it is going to drag us down, a recession is possible. And if there is a recession, obviously, a lot of the IT companies, big companies, will immediately freeze all the new IT projects. They will not. They'll probably put a lot of projects into support mode, and they will cut a lot of contractors. So the big companies, they will stop their own hiring. They will stop contracting, and that in turn will impact the lower companies, even like big companies like TCS, Accenture, Infosys, which depend on these other big companies for IT services, and that in turn will impact even smaller companies, smaller IT services companies. So in a whole, if there is recession, or if there is a continued impact on the stock market, I would think it would impact the stock market, because if you look at last 4 years, and even President Trump's market was not really impacted. The stock market always did good during President Trump's first term, during Biden's 4 years. The stock market was not impacted, and what that meant was, there was a lot of demand for people. The companies were doing good. So we just hope that the stock market comes back up, because if the stock market continues to do bad, I can definitely see a big problem for H-1B program.
Right, Chand. I mean, it's intense. I mean, all this, how would I say, the crash, 15 points, 1,500 points down even till now. So it's going to take some time. Let's see how it goes. But I'm so happy, like, that we have so many viewers and we're going to take them up quickly. But yes, the ripple effect is going to be on, not just on the H-1B applicants, visas, everybody. I think everything is going to be affected by this. So we'll just have to wait for now and watch. And we don't know what is the reason really, right, Chand?
Yeah, I
Let's
think
pick up.
because of tariffs, I think what has happened is, now we know that the tariffs that the country has levied. Now, what's going to
Mhm.
happen is, we don't know how the other countries are going to react, because China already said that they're going to retaliate, and European Union, they're talking about retaliation. So I think at a certain point, I mean, again, if these tariffs cause other countries to negotiate and lower their tariffs, maybe it will help the country in the short term and also in the long term. But if the countries start retaliating, like some countries have been coming back, what's going to happen is we don't know the impact, because the market reacts to short term news. So the market immediately is going to look at, "Hey, China is going to retaliate." They're going to see that news, and it's going to crash the market on a short term basis. But long term, we don't know how it is going to impact. Maybe the countries are going to come back and negotiate. So we don't know. So I think it is definitely something that all of us will be watching in the next couple of days, because clearly, like you said, it will be a ripple effect, because stock market is where things start, and based on the stock market, we will have a ripple effect into the entire economy. So hopefully, if things stabilize, I think it's good for the country. But if things don't stabilize, stock market starts having a prolonged impact, I mean prolonged decrease, and the markets don't come back up, I think it is bad for everybody involved. So let's hope for the best, and hope that this whatever we are seeing today is a short term impact.
Yes, Chand, we really hope so. And, I would like to tell you that we actually have a caller who's joined in, and it's none other than Shashi Kumar Reddy. Actually, I was just going to take up his comments, but happy that he joined. So, hi, Shashi. Thank you so much for joining us. Tell us where you're joining us from.
Sure. I'm joining from Seattle, Washington.
Okay, so Shashi, why don't you ask your question yourself? Attorney Chand is here. Go on.
Okay, sure. Sure, sir. I'm on STEM OPT with I-797B consular approved with my old employer. Recently, I got an offer with other employer and filed for H1 transfer with change of status. So I see the case was approved in case tracker app, and also my employer received an email for premium processing saying like H1 was approved, and it says consulate port of entry was unknown facility with I-94 number. So just want to confirm, like it's gonna take some more time to get the I-797 document to my employer. So just want to check how can I know by that email whether it was approved with I-797A or again the consular processing.
Sure. So in your case, if the employer has applied with change of status, more than likely they got change of status. I mean, I'm pretty positive they got it as change of status. That being said, what happens is the case gets approved. Within a day or two, you get that email, and that email normally will have the consulate. Even if it is change of status, they put consulate. And I think what has happened in your case is you just got that email, so you saw that email. And next, what's going to happen is in next 5 to 7 days, the company will get a hard copy, and they should get it. The hard copy will have the I-94 information, and that is the best place to confirm. And another place to confirm is ask your employer if they have done e-filing. If they have done e-filing, that approval copy will show up on the website probably within a day max. So if they have done e-filing, you can ask your employer to go to my.uscis.gov, immediately download the hard copy of the approval. So if you have e-filing, you can probably verify it today itself. If you do not have, if your company has not done e-filing, wait for about a week. Week is probably the max. And in a week, they will get the hard copy in USPS mail, regular mail, and then you'll immediately be able to see the I-94. And if you see the I-94 and you see a wording that says change of status has been approved, you're good. And more than likely, you should get change of status.
Okay, sure. But based on the email what I have received, they mentioned I-94 number from premium processing USCIS email. So can we confirm like from this email, sir?
No,
like,
no.
I know.
No, from the email you cannot confirm. Yeah. From the email you can never confirm, because we had seen multiple things. So email is just to confirm that your H-1B part has got approved. For the change of status part, you have to see your notice, the actual notice that comes in the mail. The only good thing is if your company has done e-filing, they should be able to get it immediately. So they can just log into the USCIS website, uh, get that copy immediately. If they have not done e-filing, wait for a max about 5 to 7 days from the day you got your email. That hard copy will have it. Email, you cannot really confirm at all.
Okay, sure. Good. Thank you, sir.
Well, thank you so much, Shashi, for joining us. And, I'm so glad that Attorney Chand was able to give you answers. All we really need from you is for you to subscribe to our channel. So if you haven't as yet already, subscribe to our channel. It is at Immigration Talk Show. And yes, go check us out. We are also not just on YouTube, but also on LinkedIn, Facebook, X, and Instagram. So follow us, stay connected with us. And thank you, Shashi, for joining us. I hope you have more questions and can join us again sometime later.
Thank you very much.
Thank you. So, thank you, Chand, for taking that up. And with that, friends, I really hope that you're enjoying this conversation we are having, this discussion we are having. So much important updates, and you don't want to miss out on all of these updates. So stay with us, and also you can contact Attorney Chand Parvathaneni yourself if you do want to have a one-on-one consultation. In fact, even Shashi, if you still want to continue to ask your questions, why don't you call him up? And his number is 817-523-8247. And his email address is law@spblawfirm.com. And go visit www.spblawfirm.com to get to know more about Attorney Chand Parvathaneni. So that said, Chand, I know it's been so much to say. I feel like sometimes 1 hour is very less with us. So I think we will go on to talk more. But once again, friends, don't forget to subscribe. All right. Yes. So coming back to our questions, Chand, if you can also tell us if an H-1B visa is revoked by USCIS on the Department of State, so does the visa holder have to leave the country immediately, or what are the next steps that they can take to challenge the revocation?
Sure. So again, we have two different departments. One is USCIS under the Department of Homeland Security, and then we have Department of State, which is the consulates. And normally, we do see two things happen. Sometimes somebody's in United States, they're working on a visa, maybe on H1, or maybe they're a student on F1. And if they have any criminal infractions, what happens is Department of State, which is the consulate that issued the visa, they suddenly come back and say that their visa is getting revoked. So that is something that has recently started happening on a larger scale. So even if the approval that USCIS has given, the H-1B approval, it is still valid, the consulate will come and say your visa is cancelled. And people should understand the difference between a visa and the H-1B approval. So the H-1B petition approval is issued by USCIS. The visa, on the other hand, is issued by the consulate. Anytime you hear the word visa, it is the consulate, Department of State. So sometimes even if Department of State revokes the visa for some reason, what that means is they cannot use the visa again. So if they travel out of the country, they cannot utilize that visa because the visa is cancelled, or something is wrong with the visa. So if somebody gets a notification that Department of State has revoked their visa, the, all that confirms is that their visa is not valid. And now the next thing that people have to see is their status in the country legal? So when we talk about, say, the visa got cancelled, but the H-1B petition, the H-1B approval given by USCIS, if that approval is still valid, their status is still valid in the country. So they can stay in the country until the date their I-94 is valid. So if somebody's I-94 is still valid, H-1B petition, the actual H-1B petition approved by USCIS, that is still valid, they are good to stay in the country. The only thing is, at a certain point of time, whenever they go out of the country, they have to approach the consulate and go fix the visa problem. So that is the easier one. The part where it gets very complex is if the H-1B petition itself is revoked by USCIS. So we also have some cases where USCIS does a site visit, or USCIS finds out that their employer has misrepresented, maybe something like a multiple registration fraud in the past, or maybe USCIS did a site visit, FDN a site visit, and USCIS found the employer is not paying the employee, the employer is not following the rules of H-1B program. So in those kind of cases, what happens is if USCIS finds an issue, what they do is they issue a notice of intent to revoke. So they don't just directly revoke the H-1B petition, they give a notice. So that is where the embassy is different from USCIS. The Department of State embassy, it is immediate. They immediately revoke the visa. USCIS, on the other side, they don't immediately revoke the H-1B petition. What they do is they give a notice. They tell the company that these are all the issues with the H-1B. They give 30 days to respond back, because there is due process in the country. So USCIS lets the company answer back and respond back to the allegations. And if the company is not able to satisfy USCIS, they get the 30 days, they answer the H-1B notice of intent to revoke. USCIS is not satisfied. That is the time USCIS will come back and say the H-1B petition, not the visa, the H-1B petition is revoked. And when the H-1B petition is revoked, what that means is the employee's status is terminated. If that happens, they have to leave the country immediately or change their status to another valid status before the H-1B petition is revoked. So, so the important thing is if USCIS gets into the picture, revokes somebody's status, that is the time when somebody has to immediately leave the country if they're not able to change their status. If Department of State on the other side cancels the visa, just make sure you don't use that visa again. You approach the consulate whenever you have to travel out of the country. So two different departments are out there, and depending on what the issue is, the rules are a little bit different. And if USCIS revokes somebody's H-1B petition, there is no grace period. Their status terminates as of that date. So that is one thing that people have to be very, very cautious. If the H-1B petition itself is terminated, there is no 60-day grace period. They have to stop working, and they might have to depart United States. Otherwise, they will start accruing unlawful presence. And so the main thing is, if the H-1B holder believes the revocation or the notice of intent to revoke is wrongful or unfair, that has to be challenged. And what that means is, unfortunately, in the current rules, only the employer, the H-1B petitioner, they are the ones that can respond back to a notice of intent to revoke. So if a H-1B petition has a problem, the employer gets that notification, employer has to respond back. So it is very important that employer does that. And for some unfortunate reason, if the H-1B petition gets revoked by USCIS, the companies have to immediately see if they have a solid case to file a motion to reopen, or file a motion to reconsider, or maybe sometimes appeal that revocation. And action has to be taken. And if not, that whole problem of unlawful presence being accrued is involved. So just people have to be cautious. And if there is any kind of a challenge from USCIS, it is highly important that the company responds before the deadline.
Deadlines are always important. So, friends, I really hope that you keep track and don't miss out on any, and don't ever leave anything for the last date. I know sometimes we have this habit that we'll do, we keep procrastinating, and by the time we do, it's already the last day. And if at all we had to make any changes, it just becomes too late. So, thank you so much, Chand, for that, and for taking up each of our questions also. Very, very insightful. And I would just like to tell our folks out there that we're doing this, right, Chan? We make it a point to meet up every week. And why do we do this? It's so that anybody watching us can benefit from this. So I really hope that you folks are enjoying these sessions that we have, and you do subscribe, and don't keep it for later. No more procrastination for nothing. I just subscribe now if possible, and share our content with your friends, your folks out there who are going to benefit, because the more the merrier. Why not? Everybody should benefit, right? It's free after all. Share our links and subscribe to our channel. Our handle is at Immigration Talk Show. And yeah, check us out. We are on YouTube, LinkedIn, Facebook, X, and also on Instagram. So, yes, that said, I think we should now take up Rag's comment. So, Rag, hi, I hope you're there. And Rag is saying, can a compelling circumstances, H4EAD, be possible without an I-140 filing?
So, in the current rules for H-1B, the compelling circumstances H-4EAD, the compelling circumstances, because we're talking about H-4EAD. So, one of the primary requirements is the I-140 filing is required. And without the I-140 filing, I don't think you can file H-4EAD, even if it's under compelling circumstances. I mean, I've not done that before. I don't think it can be done. Maybe warrants a little bit more research on my side. But I think based on my experience, I do not think that is possible.
Okay. Rag, I hope you got your answer. And I know Rag has already subscribed. So I really like it when, we have these familiar names and familiar users join us every week. So thank you, Rag, for your question. Now let's take up another one, and this is from Vishal. Hi, Vishal. Thank you so much for joining us on YouTube. And let's take up his question. If there is any possibility to confirm that my employer is applied H-1B for me, has applied H-1B for me, and also I want to know that when applying H-1B, educational transcript is mandatory when applying time.
Sure. And again, we hear this a lot because sometimes the employers, I mean, tell people that they have filed the H1, and sometimes they do not file. And sometimes the employers file and they don't share any documents with the employer, employees. So these kind of things keep happening. And again, in terms of the rules, this is what the rules are. The rules are very clear. If a company is applying for a H-1B, the company has to share a document called LCA. It's called Labor Condition Application. It will define what the role is. And every company, any company that is involved in H-1B program, they do not have a choice, because this is by law. By regulations, they are supposed to share the copy of the LCA before first day of employment, and this is mandatory. So LCA copy is something that every employee should ask their employers, and if employers are not sharing it, it is a violation of H-1B program. So employers have to share it, and if some employer says no, I will not share the copy of the LCA, it is a violation that if DOL finds out or USCIS finds out, it is going to be an issue. That is one thing. And the second thing is, the easiest way for you to confirm is ask for a copy of your receipt. And if you have a copy of your receipt, that is the easiest way to figure out that the company has applied for a H-1B for you, because you will see your name, you will see your receipt number, and you can like go online, type in that receipt number, and you can see the status of that case. So that is very important. And if the company gives you the receipt number, it is pretty easy. If the company does not give you the receipt number, or say the company has applied and you got an approval, you have not received the approval, the only way you can get a copy of that is you can reach out to USCIS. And if you normally call them, they will not share any information, because they will say your employer has to be on the call. But there is something called Freedom of Information Act. So if you do a FOIA request, Freedom of Information Act request, and it is pretty easy, you can just go online and do it. If you do a Freedom of Information Act, that is another way. USCIS normally will come back. Normally we see 30 days to 60 days, and they come back. They will give you a record of your immigration file. So if some employer is not sharing a copy of some approval, the easiest way is approach USCIS and approach them through a FOIA request. If you do it through the FOIA request, you might be able to get a copy. And in terms of educational transcripts, educational documents are mandatory at the time of filing. If you do not file it, you might get a very bad RFE. And proving that the beneficiary qualifies, that means you qualify for that position, that is mandatory. And just showing the degree is not enough, because the degrees come in multiple names. Sometimes it is called information system, sometimes it is called information engineering, sometimes it is called computer science, sometimes it is software engineering. So the names of the degrees could vary, but if you do not provide your educational transcripts, when you say transcripts, we are talking about the mark sheets, the coursework, that show what kind of courses you have done, and so on. So the transcripts are super important, and if they are not provided, you will get an RFE. Sometimes the RFE could be pretty bad. I mean, you might not get a direct denial, but you probably will get a very nasty RFE sometimes. So to avoid it, I mean, the best thing is just provide the educational transcripts upfront. These are super mandatory. You don't have to provide the originals. You can just provide the copy, because you don't submit originals with your filing. You submit copies. So definitely educational transcripts are super important. And I mean, you can skip an evaluation. Again, if you think that evaluation is not required, you might skip an evaluation, but do not skip the transcripts. The transcripts are super important.
Absolutely. Thank you so much, Chand, for taking that up for Vishal. And Vishal, I really hope that, because we see your questions, I would tell you, so sorry, Papa Kipari. Yes, we are going to pick your question. I'm going to take it up next. So I just want to tell you folks that, yes, we really see your questions and we bring you experts and attorneys. Thank you so much, Chand, for joining us today. So now is the moment, for you to subscribe to us and share our content, like if you haven't already. And our handle is at Immigration Talk Show. So click, confirm, contribute, I would say. And that's how we grow together, right? So, all in all, that's all we need from you. So,
Yeah.
stay with us. And Papa Kepari, now let's take your question. So sorry to keep you waiting for so long. Let's go on with the question. Pratibha here. Okay, hi Pratibha once again. Employers submitted 221G RFE in February, I guess, waiting since January 2025. Case updated, date changed 4 times till now. No further update. In house project, consulting company. Okay, that is what she says. That is the information she shared.
Sure. So, so the good thing is, looks like your employer has submitted the 221G response. So normally, what happens when you get a 221G is the employer gets email. So the employer gets contacted by Department of State. They send a bunch of questions, and they try to validate some information. So the fastest way to speed up things from the company perspective is answer that 221G response, that email as quickly as possible. And once that information goes back to Department of State also initiates other background checks. Sometimes they contact the landlord. In your case, since it's an in-house project, there is no client. The landlord, whoever is the landlord that leases the space to this company, they might have got contacted. And sometimes if they do not respond back on time, cases get held up. And sometimes even if the company has responded and the landlord has responded, they keep doing their background checks. And what recently happened is, in the month of February, just the last week of February, there was a DOS cable instructions to the consulates where the consular officers were asked to do some more additional vetting, social media vetting, and so on. So, because of extreme vetting that is going on and the rule changes that are happening since 2025 January, the burden on the consular officers also has increased. They have to do more vetting. Department of State is doing more vetting. So since it is December and the company has responded, and normally what we see is about 8 weeks nowadays, about 2 months. So 60 days is probably something that could be taken. And the very fact that you see your date updated 4 times, what that means is they are actually not sitting on. I mean, the file is not sitting on the table, but work is actually being done. I mean, I think there are background checks happening on the company, on the lease, various other things. So I think they are in the process of completing your file. And this is what I suggest: wait for about 60 days, because you do have to give them the time. Once you cross that 60 days, the employer should contact the consulate. They should probably contact the consulate probably once every week, and go back to the consulate and in an email ask them if they need any other additional documents. If not, justify the business reasons, and request them to speed it up. Okay, so wait for 60 days, have your employer reach out to the consulate, have them send out an email, and see what's going on.
Okay. Thank you so much, Pratibha, for joining us. And well, I hope you got your answer and all the best. Looks like it's good because it's not sitting and they're working on it. So you should get your answer soon. Thank you so much. And don't forget to subscribe if you haven't already and share our content, Pratibha. Thank you. And quickly, we will take up Rag's question, the another question he joined us with. So Rag is asking, part-time H-1B can get through USCIS, but what are the chances of the consulates?
Yeah. So part-time H1Bs are completely legitimate, and companies can apply for part-time H1B. There are a couple of ways they have to do it. On the LCA, they have to say it is a part-time H1B. On the I-129, they have to say it's a part-time H1B, and specify the number of hours. And that being said, when you go, I mean, like you said, USCIS does not have any problem with it, with part-time employment, with part-time H1Bs, because it's completely legitimate. You get an approval here. You go back to the consulate. So at the consulate, the main thing they're going to scrutinize is, are you going to United States to comply with the terms of your visa? So the part time, when you say part time, it can be 5 hours, it can be 20 hours, it can be 25 hours. So what they say is they also see how much money you are making through this employment. So the thing is, if it's employment where you're reasonably making decent amount of money to survive in the country, even if it is part time, they don't have a problem. But again, you can expect a little bit more vetting, because they want to make sure that you are going to work part time, but you're not really spending the other time that you have to do a job, an unauthorized job. So maybe working at a restaurant, maybe working as a Uber driver, for example. So these are the kind of things they want to focus on. So what that means is, yes, there will be a little bit more additional vetting. They want to make sure, yes, you're going there to do only this part-time H1B job, but you're not going to do something else, something that will violate your H1B status. So there will be some questions around it. And also they want to make sure, because it's part-time, because the salary is going to be less, is that enough for you to sustain? So you might have some additional questions, but again, every case is different. I mean, if the salary is decent enough, even with part-time, you're able to make a living, and it makes sense for them, I don't see a problem. It's completely legitimate. uh, I mean, all you have to convince the Department of State consular officer is that, yes, you will comply with the regulations, and yes, the company also has a real, genuine, bona fide job, and there's really a good reason for them to do it as a part time. Because some companies misuse part time. They say it is part time, they make people work for full time because they feel that they can escape by paying for part time salary. So there have been issues in the past. So the main thing is you can expect additional vetting. They just want to confirm that the company is not exploiting you by marking this job as a part time and making you work as a full time. So questions surrounding it is what you can expect, but just by itself, I don't think you'll have a problem because it's a part time H-1B employment.
Okay, okay. Very interesting. Thank you so much, Chand, for taking that up. And also, Rag, for joining us with your question. So, okay, Pratibha is back with another follow up asking 60 days after RFE submission? Question mark. Thanks for answering. I think yes.
Yeah. So in your case, I think since we are referring to 221G, so it is a 221G response. So normally, once I mean, I would say if it is 60 days from the date that you attended interview and everything is sent to the Department of State, the
Mhm.
consulate, I think it's a good time to reach out. So I think at least definitely 60 days after your initial interview date, I think the company should reach out to Department of State, the consulate, and also after 60 days after your document submission. So I think definitely there's no harm if the company contacts the consulate right when you reach the 60-day mark of your interview date. That is the first time they should contact the consulate. And then again, if they don't get a proper response, definitely 60 days after the response was sent out to the consulate.
Okay. Thank you, Chand, again for taking that up. And Pratibha, I hope now you've gotten your answers. And Control, if you can, get our questions ready from our Facebook groups, it'll be very good to take them up right now. So, also, friends, I would just like to tell you that we are doing this not just for us, but for all of us to benefit. So, why not give us also, let's make it a win win for all sides. So, follow us, subscribe to us. Our handle is at Immigration Talk Show. And you can also check us out. We are not just on YouTube, but also on LinkedIn, Facebook, X, and also on Instagram. And of course, we have Chand Parvathaneni, who you can also contact in case you want to know more or discuss more about your case. His number is 817-523-8247. And you can go email Attorney Chand Parvathaneni by emailing him at uh, law at spblawfirm.com, and go visit www.spblawfirm to get to know more about Attorney Chand Parvathaneni, of course. And I see more folks joining us. Just stay with us. We will quickly take up this question first from Facebook. So, yes, this is from an anonymous participant saying, I'm selected in lottery. What are the next steps? Currently, I'm on a student visa and based in UK, but I am Pakistani national.
Sure. So the next steps are so the good thing is it's good news. The lottery selection has happened and you have been selected. So the next thing is your employer has to file the H-1B petition before June 30th. So that is a sharp deadline. So before June 30th, the company should file for the H1. And since even though you're a Pakistani national, you're based in UK, what your company will do is they will ask for consular processing, and they can select UK consulate because you're residing in UK right now. They can ask for the consulate in UK to be notified, and you can attend your stamping, your H-1B visa stamping in UK once the H-1B is approved. So the main thing is follow up with your employer, make sure they do the filing before end of June, and let them know the consulate that you will be attending your interview in. So if you're going to attend it in UK, just let them know the consulate name so they can make sure at the time of their filing they can put the proper consulate name in their I-129.
So, Chand, okay, thank you so much, Chand, for taking that up. And I think we do have more viewers, so we'll quickly take these first. This one is from Charles. Hi, Charles. Thank you so much for joining us. I hope that you have subscribed to our channel. If not, do subscribe. Our handle is at Immigration Talk Show. You can already see. So, Charles is asking, please, my employer is an H-1B cap exempt. How does he apply to prove it is a cap exempt?
Sure. So I think normally it is pretty straightforward. So for example, so there are requirements on when a company is cap exempt. For example, a company is a not-for-profit organization. It is it is affiliated with an academic institution. For example, they're cap exempt. So what the company will have to do is they'll have to look at the cap exempt requirements, and they have to prove through those documents. For example, if it is like a hospital that is affiliated with a university, what they will do is they will show that, for example, they're not for profit, and next thing they will show is they'll show evidence that they're affiliated with a particular, for example, a medical school, for example, and they prove that they're cap exempt. For example, if it's an education institution, they will show their IRS documents to show that they're not for profit, and then argue why they are cap exempt. So in general, it should be pretty easy. So just there are requirements on what kind of entities are cap exempt, and they just have to prove evidence, maybe through IRS documents that prove that they're not for profit, their profile that they are exempt organization, and then they should be able to move ahead. In general, most of the time, universities, research organizations, or hospitals affiliated with other universities, these are the kind of entities that are cap exempt. And the attorney that's working on the case, they should be able to figure it out pretty quickly. And the documents are not very hard. I mean, most of the time, the employers, if they're already a cap exempt organization, because very select few entities are cap exempt, and it is pretty easy to figure it out, because if the company is a research organization, educational institution, or a hospital affiliated with another university, etc., it is very easy to prove that kind of evidence.
Right, right. Thank you, Chand, for taking this up for Charles. And Chand, if you don't mind me asking you, I really hope you have some more time to stick with us because I see a lot of viewer questions and I don't want to disappoint any
Sure,
one of
sure,
them.
sure.
Okay, so this is Ayush asking, hi, I got my petition approved in December 2024, but the employer is not sharing the documents to schedule my interview as previous candidates got 221G. Waiting for their case result. So it seems waiting for their case result. Please suggest. Can I transfer the petition with some other employer?
Sure, sure. So, I mean, again, there are two options. One, you talk to your employer and ask him if they still have a job and if they're in the plan of sending you for stamping, because the company will need to have a bona fide offer still valid when you go for the visa interview. So tomorrow, if they do not have a bona fide offer and you go for the interview, tomorrow you can run into an issue with misrepresentation. So the first thing is, check with the company, check with the current employer, the current H-1B petitioner, and see if they're going to send you for stamping. Uh, the bottom line is, if they are not able to show genuine bona fide employment, the next thing that you should look for is transfer. Yes, you should be able to transfer, because once you got an approval, if that approval is still valid, not revoked, what that means is you can actually, if you have another offer from another employer, your petition is a cap exempt petition. The reason is you have an approval in the past, you have been counted in the lottery in the past, and based on that, you can do a transfer. And that is what we see with a lot of people, because the employers, they have a project at the time of filing, and later on, for some reason, they're not comfortable in because they feel that they're getting more 221Gs, or sometimes maybe because that project is over, the project is terminated, or for whatever reason. And in your case, because you cannot keep waiting forever, and your recourse is, if you have a better offer, if you have a different offer from another legitimate company for a bona fide offer, that company can do a transfer. And we have seen that happen a lot of times. I've seen people, they are like fed up with the current H-1B approved company, and they just get a better offer. And since they get a better offer, it is a legitimate way of transferring your employment to another employer.
Okay, okay. Well, thank you so much, Chand. I mean, those were very important updates, and I really hope that Ayush, you too, you got your answer. And I see that Charles is saying, thank you so much, attorney. So, Charles, also, thank you so much for joining us with your question. I would just appeal to you to also contribute to us by just subscribing to our channel. You just have to do it quickly and hit that bell icon so that whenever we have discussions like these, you are notified and you can always join us, to ask any questions about immigration, or yes, tell us about your story as well. So thank you so much, Chand. And also Rag says, thanks, Chand, appreciate your inputs. Thank you, Rag, always a pleasure to have you watch us. And I think with that we have taken up most of our comments from our folks here on YouTube. So I hope that everyone out there have has enjoyed this conversation so far. In fact, I really had a few more questions, Chand, from our Facebook group. Do you have 5 more minutes?
Sure, sure. Yeah, let's go
Okay,
ahead.
let's do
Yeah.
this then. Well, let's have it on our screen. This is from an anonymous participant. Student visa second attempt. I got rejected in 2024. Now my uncle wants to sponsor me financially. He has a good position in USA. I'm showing his bank accounts and statements. What is my chance?
Sure. So whenever circumstances change, people can always go back for another interview for student visas. So the only thing is when somebody is going for a student visa, the consulate is looking for two things. One, the intent, which is to go and study, and whether financially does he have the resources. The second thing is they're also looking to make sure the student, after completing their studies, has enough ties to come back to their home country. So, in terms of financially, if in case the finances were a problem the last time, definitely somebody who's in US can sponsor him, can show financial support. However, the next thing is ties back to the home country. So, if somebody in US is sponsoring somebody's tuition, again, if the consular officer is not satisfied that there is enough ties back to the home country, because financially does not have enough assets back in the home country, the consular officer might deny that student visa. So theoretically, yes, it is possible, and because circumstances have changed, he can go for a visa stamping again. But most of the successful cases that we see are cases where somebody has strong financial ties back to their home country. If there are no strong financial ties back to the home country, typically it's always hit or miss, because a lot depends on how the officer feels on the intent of that particular visa applicant.
All right. Thank you, Chand, for taking this up. And now let's go on to our next one. This is also from an anonymous participant. Will it be an issue if I go to another state or visit and then to my university address after a few weeks of visit? Will it be an issue in port of entry?
Theoretically, it should not cause any issue. But that being said, what normally happens is at the port of entry, the officers are asking for the intent. They're asking for, like, they ask about various things about somebody's travel and travel plans. And again, it depends on the officer. If the officer feels that something is not right, they'll be called for secondary. But if the officer is convinced, they see the travel plans and they understand, yes, okay, he's going for a visit and then he's going back to his university, it might be okay. So what that means is a lot depends on the CBP officer, and how that message is conveyed back to them and what they feel, because they are looking for any kind of pointers, any kind of red flags. And again, it's very common that people go visit like family before starting their school, and people have legitimate reasons to travel to some other place, then join the university. So upfront, I don't think there is a problem. But again, be prepared for questions, and if they question you, just convince the officer on your real intent to visit temporarily, and all those other things. So again, it just depends on the officer. I mean, most of the time people are okay, because even if they go to secondary, and again, if that is what they find as the intent, there should not be any problem.
Okay. Yes, absolutely. And we do have more questions, and I see Anand asking questions. So that's if that's a question, then yes, we are taking up questions. If you have any questions, please ask your question. We will take your question. That was a lot of questions. Okay. Anyway, so anonymous participant is asking if I call for my I-20 from a particular university, but later don't go to it. Is it possible to email them and let them know about a change in my decision? Will they allow? Will they charge any penalty? Or this has any legal implications?
Again, if somebody gets an I-20 and they have change in plans, the legal way to do it is make sure you're working with the school DSO, make sure your service is transferred properly. So if the service gets transferred appropriately, the service is not terminated, normally it should not be an issue, because people have change in plans, and they have genuine reasons. So if somebody is doing it, changing their university, transferring to a different university, they got an I-20, they don't join that university, that is probably okay from immigration perspective. Just make sure that you're notifying the school DSO and doing it in an appropriate way, and they should not charge any penalty or any of that sort.
Okay. Thank you, Chand, for taking that up. And I think we will take this as one of our last questions from our Facebook group. But Anand, if you have any question, please quickly tell us what is your question, because we are going to wind up very quickly. And this anonymous participant is asking on our Facebook group. Hello, all. I completed my DS 160 form on November 23rd, 2024, and I scheduled my visa interview appointment in May 2025. I want to postpone my trip due to personal reasons and would like to reschedule the visa interview. So, my question is, can I postpone until November 2025 or May 2026? Thanks in advance.
So the consulates, they're currently giving one chance to reschedule, so they should be able to reschedule. So you might have to reach out and reschedule your appointment. So one time, people are able to reschedule their appointments currently. More than once, they have to again pay and again redo their entire appointment again.
Okay. Okay, thank you so much, Chand, for taking all of our questions so patiently. I mean, it was simply amazing to have so many folks out there ask their questions as well. I was actually waiting for Anand's question. And Anand, if you can hear me on LinkedIn, I'll be really happy to receive what question you have, because we have Attorney Chand here who will be happy to answer. But also, Chand, before we say bye for today, would you like to, leave us with an end note, especially on the topic of discussion we had today, and maybe a few updates or
Sure,
some
sure.
things to keep in mind?
Sure. So one thing I definitely want to kind of emphasize is uh, last week of February, the Secretary of State Marco Rubio has like publicly stated that 300 visas for people who are already in the United States have been cancelled. He has stated that. And on top of it, this week we are actually seeing. I mean, this is like first-hand information. We have seen emails from our clients, emails where the consulates. I mean, I've seen three consulates so far. I've seen Chennai, I've seen Mumbai, I've seen Delhi. Three consulates where people got emails, and those people are in United States. They got emails and said their visas have been cancelled, and they have to like go out of the country. If not, if they don't self deport, they could be deported. So it's a very threatening kind of an email that we saw. And again, the common pattern is these people had some infractions, maybe minor, but again, end of the day, they had some criminal record. Maybe things like shoplifting, drunk driving, DUI, driving under influence. So these kind of things. So what that means is, because the focus is so much on criminal offenses, no criminal offense is small. Even a small offense is still an offense. So the bottom line and the suggestion for everybody is, be extremely cautious. Always follow the rule of the land. I mean, sometimes you have peer pressure. Don't get influenced, especially with drunk driving. You have a party in the weekend and like your friends influence you, and you think it's only a little bit. You only have a block to drive, but that could kind of jeopardize your career. So always follow the rules. Don't take any chances. Even minor infractions are getting running into major issues. So always be cautious. And so these kind of things we have just started seeing. So even a small infraction will jeopardize your career. So uh, don't do anything that could hurt your US career. And 99% of the people, I would say more than 99% of the people, don't have to worry about these things. But it's this 1% that sometimes get influenced by their friends, and accidentally they do mistakes. Okay, so just always pay attention. Don't get influenced by your friends. Be extra cautious.
Absolutely. So I think with that, I would just say be good, and do what you're there for. So don't get distracted by other things. Focus on what you're there for. If you're a student, go do it, and if you're working, work hard. All the best to all folks out there. Thank you so much, each one of you, for joining us. And yes, don't take too much risk. That's also bad. That's from our controller here. He's also giving out. So thank you once again, everybody, and yes, love it that you joined us today with all your questions. Please do not forget to subscribe to our channel. And if you have already, also share our content with your friends and family, whoever can benefit, because this is free content and many can benefit. We don't want to miss out on that too. And all we need from you is some support, and that you can do by following us, connecting with us, and subscribing to our channel. So, once again, thank you so much, Chand. And it was lovely having you. It was such an insightful session. I wish we could keep continuing, talking and learning so much from you every time you visit us is always great. So thank you, Chand.
Thank you,
See you
Nipasa.
soon. So, friends, do check out Attorney Chand Parvathaneni, and you can go check him out in his website. His website is www.spblawfirm.com, and definitely you can contact him or get a one-on-one consultation about your case. His number is 817-523-8247, and go email him at law@spblawfirm.com. And that's it. Well, once again, have a great day, Chan. Thank you once again for joining us. And folks, you can also email me. My email address is nipa@staffingly.com. And you can also WhatsApp me or call me on my number. My number is 408-335-6444. And yeah, have a great day. But stay tuned here on Immigration Talk Show because there's more coming. We also have another webinar lined up with none other than Attorney Uma Mantravadi from Mantra Law. And well, my host Sam is going to be there for that session. So stay tuned to our channel. And we are also going to join you, both me and Sam. We are going to join you for on daily immigration doors with another very interesting content. Interesting topic of discussion to discuss about. So, yes, bye bye for now, but don't go anywhere. Keep watching Immigration Talk Show.